Alpen Pharmaceuticals in association with Higher Secondary Principals Forum.
Good day, students. We are coming to the last part of our chapter on issue of shares. Now you have seen we have completed the procedures, 3 procedures we have completed: application procedure, allotment procedure and call procedure. Now in allotment of shares we have completed provisions of allotment and also we have completed provisions of calls on shares. So I hope everything is clear to you on what has been discussed. Now before I go on to my lesson of today, I want you to have a look at the screen very carefully. Now this chapters that I have put for you of our SP syllabus is the revised syllabus only for this academic year 2020-2021, only for this year. Students, please make a note. It is only for this academic year. Now in my first lesson, I had told you that issue of shares according to Goa board allocation of marks was allocated 12 marks. But now they have revised the marks allocation for all the chapters, and the new allocation of marks given to this chapter is 20 marks. So please make a note, this chapter is given 20 marks. So also correspondence with members of a company and directors of a company is 10 marks. Companies Act 10 marks, Stock Exchange 10 marks, company meetings 10 marks, minutes 10 marks and report writing 10 marks. Okay, the marks distribution has changed and 2 topics are omitted: correspondence with banks and correspondence with insurance companies. So for this academic year, this is the syllabus you will be studying and these are the marks allotted to the chapters. Please make a note of this. Thank you. Now I go on to my lesson for today. Now today I am going to teach you transfer of shares, meaning, provisions and procedure, and transmission of shares, meaning, provision and procedure. Now students, this is the last part of our lesson of unit 1, issue of shares. This is the last part of our chapter. So now the first thing that I go on to is transfer of shares. What is the meaning of transfer of shares? When a shareholder voluntarily transfers his shares by sale or gift it to another person. Okay? Here he is voluntarily transferring his shares to another person. No one is forcing him. So how he is transferring it? Either he sells it to another person or he may gift it to another person. There are 2 parties involved: a transferor, who is a person who wants to transfer his shares, and a transferee, in whose favor the shares are transferred. That means who receives the shares. So 2 parties involved, transferor and the transferee. The person who wants to sell it, a person who wants to buy it. Now what are the provisions of transfer? Please make a note of my topic that I am doing to you right now. Provisions of transfer of shares. So when you want to transfer your shares, what are the conditions that have to be fulfilled? So the first one is instrument of transfer. Now it is also called as a transfer deed, or instrument of transfer, a transfer form. Okay? Now the transferor, he has to get this transfer form stamped and dated by the Register of Company. So both of them, both the parties who are interested have to go and get this form from the Register of Companies And when the Register of Companies gives you this transfer form or the instrument of transfer, this form has to be stamped and dated. Now you can see over here, the transfer form is submitted to the company on behalf of the transferor and the transferee within 60 days. 60 days of what? 60 days of receiving the form from the ROC. Okay? It is 60 days of receiving the form from the Register of Companies. So this form has to be given to whom? To the company. Both of them, the transferor and the transferee. And when they give this form, they have to also submit the share certificate. So who has the share certificate? The transferor. So he has to bring the share certificate, and along with the form, they submit it to the company. From where they get the form? From the Register of Company. That is the first point. Then the second one is, if the transferor makes an application alone and the shares are partly paid up, the transfer is not registered. So what this shows you, that when you want to transfer your shares have to be fully paid up. But then again, they may consider it if both the parties go together for transfer of shares, transferor and the transferee. They may consider it if the transferee has no objection. Okay? The transferee should have no objection that the shares are partly paid up and the shares are being transferred to him. Only then transfer can take place. Otherwise, transfer does not take place when shares are partly paid up. Shares have to be fully paid up. So in the second part you can see here, unless the transferee gives an application of no objection, you can see the no objection on the screen. Within 2 weeks of receiving the notice, he has to give this no objection to the company. Then the next point, delivery of share certificate. The company should deliver the share certificate within 1 month from the date of receiving the transfer form. So suppose I am a transferor and I want to transfer my shares to transferee and I submit the form to the company, the whole procedure should be completed by the company within a period of 1 month. Okay? It has to be completed within a period of 1 month. The company should give me the new share certificate to whoever the person is. Then, transfer by legal representative. Now, please make a note here, pay attention. Now, this happens when a shareholder dies. If a shareholder dies, the legal representative will request for transfer of shares. Then it is valid. Okay? So, this happens when a shareholder dies, the legal representative can request for the transfer of shares. Now you can see here, this person is saying no. So what it means? Time limit for refusal of registration of transfer. Refusal of registration of transfer. So if the company does not transfer the shares and they have a problem with something, they have a time period of 30 days. So the company can refuse to transfer the shares. So the power of refusal to register the transfer of shares is exercised by the company within 30 days of receiving the transfer form. So if they want to refuse, they can refuse, but they have to give a valid reason. Give a valid reason why you are refusing to transfer the shares to another person. So the time period given to the company is 30 days to refuse this. Now, if the company refuses it, now you can see on the screen, look very carefully. Okay? First I will read to you, then I will explain the picture put to you. The time limit for appeal against refusal to register transfer by public company. So what happens? If a company has refused you transfer of shares, you can appeal for it. Now how you appeal? You appeal by going to the court. So that's why I put for you a bench here, you can see, of 3 judges where the matter is put for appeal. Why shares are not permitted to be transferred. And I put that symbol for you where you know the judge gives his final decision by banging it on the table. Okay? Now see, a transferee of shares may within 60 days of such refusal, and no intimation has been received from the company. The company has not even intimated them. The company has not even told them, okay, that they are refusing to transfer shares. So what the transferor can do, okay, or the transferee can do, they can appeal to the tribunal. Within how many days? Within 90 days. So within 90 days of receiving the transfer form, they can appeal to the tribunal, okay, as to why the company has refused to register their transfer of shares. So I hope I am clear with the meaning of appeal to you. So if the company has refused to transfer your shares, they go up to a higher authority, and the tribunal is like a court that looks after settlement for companies. When companies have any disputes, they look into the matters. Now, the next subheading is when directors refuse to transfer shares. What is the reason? Again, as I told you, the provision should be put in your articles of association. But what are the valid reasons when a director can refuse to transfer shares? The first one is if a person is a minor, okay, and you know that a minor cannot enter into a contract. A minor is a person who is below the age of 18 years. So a person below the age of 18 years is considered incompetent to enter into a contract. So they may refuse to transfer shares. Second reason is when a company has shares on a lien. Now what is a lien? Suppose you have taken a loan from the company, you have taken an advance from the company, okay. That is the time you cannot transfer your shares till your loan is paid up, not forever, till your loan is paid up. Once your loan is paid up, definitely you can transfer your shares. The third reason is when a transferee tries to take transfer of a large number of shares. For what reason? To control the management of the company. Okay, there are people who do this. They try to buy up the shares of the company in order to get the control of the management of the company. So when the directors realize this transferee is doing this because he wants control of the management, they will refuse to grant shares, transfer shares. And the next, if the shares are partly paid by the shareholder. In our provisions we also saw the same point. If your shares are partly paid up, unless the transferee gives a no objection, otherwise they will refuse to transfer shares. And if the transfer form is incomplete or is not submitted within the given time. So the transfer of shares will not take place if your form is incomplete. You have not signed or you have not paid the fees, then they will refuse to transfer the shares. So I hope you have understood when directors refuse to transfer shares. Now we are going on to the next, that is procedure. Again remember students, procedure I told you it has to go in a particular order. So what is this procedure we are studying here? Procedure for transfer of all shares held in the physical form. So the first point, instrument of transfer. Now instrument of transfer, transfer form, as I told you, this is all the same thing. So the transferor has to get the transfer form which must be dated and signed by the ROC. This we already did in the provisions. Then second, both the transferor and the transferee has to fill in the transfer form and sign the transfer form in front of a witness. Okay, when you are completing the work, a witness has to be there saying that yes, both these people have agreed, one has agreed to transfer and the other has agreed to buy the shares. Then third point, the transfer form is filled and submitted to the company's office along with the share certificate. As you can see, they both are giving the transfer form along with the share certificate to the company. Now, this transfer form must be submitted within how many days? 60 days of receiving the form from the Register of Companies. I told you the transferor and the transferee gets the form signed and dated by the ROC, which they fill in and give to the company. So, from that date from which they bring the form from the Register of Companies, within a period of 60 days, they have to submit it to the company. Now, what the secretary will do? You can see she is scrutinizing all the documents. Okay, scrutiny means what? Checking, carefully checking. Okay, she is carefully checking. So, what she is checking now? The company secretary checks all the details of the transfer form and the share certificate with the Register of Members. Now, both these documents I told you are given by whom? By the transferor and the transferee to the company. So, the secretary checks all the details with what she will check? With the Register of Members of the company. Are you getting? It is checked with the Register of Members. I told you they maintain a register in the company. So, they will check whether all this information is correct. Now, if they are satisfied, if the secretary is satisfied that yes, all the details are correct, she will give a transfer receipt, okay, to the transferee as an acknowledgement of the documents. So, this receipt you have to keep with the transferee, has to keep this till the whole procedure of transfer is completed. Okay? So, because they are submitting the share certificate also. So, what proof do you have that your documents are with the company? So, because of that, the secretary issues a transfer receipt. I hope it is very clear to you what I am telling. Then next, what the secretary does after that? A secretary sends a notice of lodgement to both the parties, the transferor and the transferee, informing them about the transfer of shares. Okay, tomorrow they should not say, I didn't know that the shares were being transferred. Sometimes people may try to forge the transfer. So, to be on the safe side, it is the company's rule that a notice of lodgement is sent to both the parties, to the transferor as well as the transferee. Okay? And if they have any objection, they should inform the company within 15 days. So, the due date will be 15 days for them. Within 15 days, they have to inform the company if any objection. Now, suppose I am the transferor and I am not asked to transfer my shares and somebody is trying to forge my signature and doing the work on my behalf, and I receive this notice of lodgement. Within 15 days, I complain to the company and they stop the transfer of shares. Okay? So, notice of lodgement is sent to both the parties. And if any objection, as I told you, they have to reply within a period of 15 days. Then, once the matters are clear, they have received no objection from either of the parties, the secretary will arrange for a board meeting. Again, I told you, board of directors take the final decision in the company. So, the secretary calls for the board of directors meeting regarding transfer of shares. So, if they are satisfied, they will pass a resolution and say, okay, transfer the shares. But they have to be satisfied with all the things. Then our secretary has to make the changes in our register of members. So, once the board of directors give their approval, what the secretary has to do? She has to update the details in the register of members and the register of transfer of shares. Register of members is where all the details. So, what she does? She will take out the transferor's name and she will enter the transferee's name in the register of members. And also in the register of transfer, one more book is maintained, register. That register things are entered only when shares are transferred. That is why it is called as a register of transfer. So, only when the shares are transferred, information will be entered in this register. So, she makes the changes, she has to make the changes in both these registers. So, again as I just told you, the name of the old shareholder is removed and the name of the new shareholder, that is the transferee, is entered in the register of members. Then the secretary will issue a share certificate. Now, how she issues a share certificate? Sometimes, now suppose this is your face of your share certificate, at the back, that is what we said here, on the reverse of the share certificate. On the back part of the share certificate, there are columns where you can enter the transferee's name. Once the columns are filled up, they will issue a new share certificate. Okay, so what happens here? The secretary makes the changes on the reverse side of the share certificate and she will inform the transferee to collect it from the company. Now, what was given to the transferee earlier? He had to keep a document with him because his documents were submitted to the company, a transfer receipt. So, he has to take the transfer receipt and he has to go to the company, show the transfer receipt and collect his share certificate. Okay? So, I hope this is very clear to you. That is transfer. Now, we are going on to the next, transmission of shares. Let me tell you, transmission means what? Transmission is also transfer of shares, giving the shares to another person. But what are the circumstances? Now, you can see it refers to passing of property of shares by the operation of law. That is, when a shareholder dies, he becomes insolvent or he becomes a lunatic. That is when transmission takes place. So, we call this as an involuntary assignment of shares. Why we are calling it an involuntary assignment is because none of us want to be in those circumstances, which is in the first part of the screen. None of us want to be in that, but sometimes it happens to us. Okay? So, that is why it is called as an involuntary assignment of shares, and because it is due to operation of law, you will not pay any stamp duty. No stamp duty will be paid. Okay? So, I hope you have understood. See, in transfer of shares, what it was? It was a voluntary transfer of shares by selling it or giving it as a gift. And we had two parties, transferor and the transferee. Whereas in transmission, it is an involuntary transfer of shares. And when it takes place, when he dies, becomes insolvent or a lunatic. So, see the difference over here. Okay, that is transmission of shares. Now, the legal representative of the shareholder has to produce the documents in different situations. Now, students, please pay careful attention here. Now, legal representative means if a shareholder dies. Okay? So, the next person who receives the shares, rightfully receives the shares, is called as your legal representative. So, now the first circumstance, if a member dies testate, please remember this word, testate. Testate means he has left a will. I hope all of you know the meaning of a will. When people are living, you can make a will and you can keep for whom you want to give your property to, your house to, if you have shares, to whom you are going to leave it. That is when you make a will when you are living. Okay? So, when a member dies testate, that means he has made a will and he has died. So, what happens over here? The person's name in the will have to take this will and go and register it in the court. Once he registers it in the court will issue this letter of probate or a probate of will. It is called as a letter of probate or a probate of will. So, this is the first circumstance, when he dies leaving a will. Okay? Now, the second circumstance is when he dies intestate. Now, intestate means he dies without leaving a will. He has not made any will and he has died. Now again a question comes as to who is going to receive these shares. So over here the matter will of course have to go to the court. So the court will appoint a person called an administrator and the court will issue a letter of administration. Okay, the court will issue a letter of administration. So make it clear in your mind. So member dies testate, leaving a will, what is given? Letter of probate. And when a member dies intestate without leaving a will, what has to be given? A letter of administration. In both the circumstances, the person has to go to the court. And here, as I told you, the letter given by the court to the person concerned to deal with the person who has died, deceased. Estate of the deceased means the person who is dead, it is called as a letter of administration. So now you know of two documents. When he dies testate, he will receive the letter of probate. When he dies intestate, he will receive the letter of administration. And you also have another document. This document is called as a succession certificate. So this succession certificate is given when a member dies without leaving a will. Okay, so it is either a letter of administration or a succession certificate. Again, this is issued by the court. Okay, and it has to be submitted to the company. Then we have this, which is called, once this succession certificate is given to the company, full indemnity to the company regarding transmission of shares. Full indemnity means full compensation will be given. Okay, the meaning of full indemnity is full compensation will be given regarding this. And along with that, you have to produce the death certificate. So the survivors in case of a joint holding can get the shares transmitted in their name by production of the death certificate of the deceased shareholder. That means of the dead holder of the shares, the person who has died, the shareholder who has died. You have to get a death certificate by the proper authority. Okay, by the proper authority you have to submit this document. So now you have heard of probate of will, letter of administration, succession certificate and death certificate. Now I am going to the provisions relating to transmission of shares. Again, please remember provisions or conditions. Now the first one, persons eligible to apply for transmission of shares. When are they eligible to apply for transmission of shares? The first case, as you can see, when a person is dead, on the death of a shareholder. The second case, insolvency. Now you can see the notes that are put on the screen over there. Insolvency means bankrupt. You have no money left with you. Okay, you are insolvent, you are bankrupt, no money. And the third, I put you a picture of a brain where you can see that something is wrong with the person. Lunacy. Lunacy means he's become mad, a lunatic. Something has gone wrong and the person cannot think properly anymore. So these are the three circumstances in transmission of shares. Please remember, death, insolvency or lunacy. In transfer of shares, what we said? By selling the shares, gifting the shares, or of course, when you inherit the shares. Okay? There also when you inherit in transfer, the legal representative gets the shares. But here again, you can see it is the legal representative can apply for the shares. That is the first point. Now, second point is intimation. The legal representative has to intimate to the company that he is the legal representative of the shares. So, when I see all these share certificates, okay, and I am the legal representative, say of my father, So, I have to go and intimate the company. Intimate means inform the company that I am the only person who is entitled to receive the shares, that I am the legal representative of the shares. Okay? So, that is the meaning of intimation, informing the company. Then third, now see, I have put all these various documents for you. I have put a picture so you can register it clearly in your mind. Now, when you intimate the company, you are the legal representative. First, you have to make an application. Along with the application, you can see the first certificate that is put over there, that is your share certificate. So, the legal representative has to produce the share certificate of the person who has died. The share certificate will be there, so he has to take that share certificate, get the death certificate. The second one there you can see is the certificate of death. That means the person has died and the death certificate by a proper authority that this person is really dead. Then the third one, a succession certificate, which I told you when a person dies intestate without leaving a will, it will be given to you by the court. Or the middle picture, probate of will, when he dies testate. Even when he dies testate, the legal representative goes to the court and says that he is the legal representative and the court will give him a letter of probate. That is the one. And the last one, letter of administration. This will be given again by the court when he dies without leaving a will, intestate. Now, the legal representative does not have to take all these five certificates. Okay? He has to take the first one, the share certificate, the second one, the death certificate, or a succession certificate, or the probate of will, or the letter of administration. Okay? So, these are the documents he has to submit to the company along with his specimen signature. Then they have to see this now, liability. If there are any lien on shares, the shares will continue for the liabilities till the debts are paid off. Students, now suppose I am a shareholder, okay, and I have not paid my full money on the shares. The company has not demanded for it, so I have not paid my full money on the shares. Still money I owe to the company, but unfortunately for me, I die. Now, who is my legal representative? That person, the liabilities continue. That means whatever amount is left to be paid on the shares will have to be paid by my legal representative. Okay? So, if any lien is there or any amount has to be paid on shares, see if there is any lien or I have taken a loan on shares, okay? I have taken a loan, I have kept my shares as a guarantee and I have taken a loan on the shares. So, what happens? Till those debts are paid off, till that loan is paid off, okay, the legal representative is responsible for it. Actually, I as an investor had taken it as a shareholder, but what happens? The person who will inherits it along with the loan. So, he will have to clear up the loan. Okay, that is the meaning of lien on shares. He has taken a loan on shares. If any stamp duty, payment of stamp duty is not required for transmission of shares. Now, why payment of stamp duty is not required? Because this is an involuntary transfer of shares. Whereas, in transfer of shares, stamp duty is required because there the transferor of his own will is transferring it or selling it to another person. Whereas, in transmission, it is an involuntary transfer of shares. In the meaning I gave it to you? Okay. So, over here there is no need to pay any stamp duty. Now, time limit. Once the application for transmission is given, okay, once the application for transmission is given, the company within 1 month has to deliver the share certificate. Now, what is the meaning of this? So, if you have asked, the legal representative applies to the company and tells them, I am the legal representative and I should be receiving the shares, the company has to finish all this work within a period of 1 month. Okay, now just for you to recollect, in transfer of shares also, the entire procedure had to be completed within a period of 1 month. Just to make you realize, it is the same time period. In transfer of shares also, the transferor and transferee, when they submit the transfer form and the share certificate, the whole thing has to be completed within a period of 1 month. So, also in transmission of shares, here the legal representative submits the documents to the company and the entire procedure has to be completed within 1 month. The legal representative has to receive his share certificate within a period of 1 month. If not, now what happens? Okay. Again, it is similar to transfer of shares, but this is transmission of shares. So, time limit for refusal of registration of transmission. The power of refusal to register transmission of shares is exercised by the company within 30 days from the date of intimation of transmission. So, the company has a period of 30 days if they do not want to transfer the shares, but they have to give a valid reason. Is it clear? They have to give a valid reason why they do not want transmission of shares to take place. The same as in transfer of shares. Then, time limit for appeal against refusal to register transmission by public company. They are specifying here public company. So, again the word appeal. Appeal is when you go for justice to a higher authority. Now, you have dealt at your level with the company, but the company refuses you and you feel that justice is not done to you. When do people go in appeal? Go for an appeal? When you feel justice has not been made. Okay. So, a person who gives intimation for transmission of shares may, within 60 days of such refusal and no intimation has been received by the company. The company did not even have the courtesy to intimate to them, to inform them that they are not completing the work of transmission of shares. So, what the person does, the legal representative, within a period of 90 days of submitting the documents to the company, please remember, within a period of 90 days of submitting the documents to the company, they will appeal to the tribunal against such refusal. So, this picture is already familiar to you, because in transfer procedure provision also this is made. Okay? Even in the provisions for transfer, the same point is there. So, when you are studying this related to transfer of shares and transmission of shares, the same thing is given to you. So, this is what they will do. Now, we are going on to the next. Procedure to be followed for transmission of shares. Now, over here the legal representative opts to be a registered member of the company. That means what? He says, okay, I want to be a member of the company. He is not interested to sell the shares to someone else. He says, okay, the shares are kept for me, I am going to be registered as a member. So, he wants to become a member of the company. So, he wants the shares to come in his name. So, what he has to do, the first thing that he does is, he has to submit, again as I told you, the same as in the provisions. The legal representative gives his application along with the share certificate, death certificate or succession certificate or probate of will or letter of probate or the letter of administration, any one. The last three documents is any one. Okay? But share certificate, death certificate is compulsory along with any one of these documents issued by the court, and whatever fees Okay, if the company is taking some fees to do the work to transfer it onto his name, that fees has to be paid to the company. Then second point is the company records all the particulars of the death certificate and gives a reference number to the entry of to the legal representative. So, what is done here? Once you submit these documents to the company will give you a number. So, every time you go back to the company till your work is completed, you have to give the reference number which is given by the company to you. Okay, that is the meaning of reference number. They take your documents and they will tell you this is your number. So, every time you go to the company to deal with this matter, you give this number that is given by them. Then what the secretary does, she will verify the documents to see if they are in order. Verify the documents, immediately what you should think of? ROM, Register of Members. Okay, so she will check these documents if all the details are correct with the Register of Members. Then is estate duty. Now, the company has to inform the controller of estate duty about the death of a shareholder. So, the moment a shareholder dies, the company informs the controller of estate duty. Who is the controller of estate duty? Okay, the controller is dealing with all these type of matters. So, the moment the shareholder dies, the company has to inform the controller of estate duty. And the secretary sees that the legal representative pays the estate duty. It is like a fees that you pay to them. But the company will not bear the expenses. The company sees that the legal representative pays the fees. This estate duty, whatever it is, will be paid by the legal representative. Then, of course, once all this is clear, the estate duty is paid, the controller of estate duty is informed, then the secretary, as I told you, will arrange for a meeting of the board of directors, and the board of directors have to give their approval regarding transmission of shares in favor of the legal representative. Okay, so, if everything is in order, then final decision, still the final decision lies in the hands of the BOD. So, if they find everything is in order, they will transfer the shares or give the shares in favor of the legal representative. Now, what our secretary has to do? The first point. So, the secretary makes the changes as I told you in the register of members. Okay. The legal representative becomes a member of the company. Okay, she becomes the member of the company. So, the person who is dead, the shareholder, will be written over there, he is dead, and now whoever is the legal representative, his name will be entered in the register of members as a member of the company. Now, because he is a member of the company, he is liable to pay the calls made by the company. Now, this I told you earlier. Suppose you have taken a loan or the shares are partly paid up, okay, and the shares are not fully paid up. So, when the company makes a call, a demand made by the company to pay the money, the legal representative has to pay the money. Is it clear? Earlier I explained this to you. When there is a loan on shares or there is the shares are partly paid up, okay, who is responsible? The legal representative. So, here he becomes liable. He becomes liable means he has to pay the money on the shares which is unpaid. Okay, that is the next. Then register of probate. Now, this is a separate register which is maintained by the company only in case of transmission of shares. So, the secretary also enters the contents of the probate of will or letter of administration or succession certificate in the register of probate. So, a register of probate is maintained. Two registers are maintained, register of members and register of probate. And in this register of probate, all the details which is issued by the court will be entered in this register of probate. In transfer of shares, two registers were maintained, Register of Transfer and Register of Members. In transmission, two registers are maintained. What are they? Register of Probate and Register of Members. Register of Members is common for both. Okay, but in transfer, Register of Transfer, in transmission, Register of Probate. And the last point, the secretary cancels the old share certificate and issues a new share certificate in the name of the legal representative within 1 month of the request for the transmission of shares. So, I told you this entire procedure has to take place within a period of 1 month. Okay. So, what she does here, she cancels the old share certificate and prepares a new share certificate in the name of the legal representative. So, whoever is the legal representative, a new share certificate will be given in his name. Okay. In transfer of shares, what I had told you, I hope you remember, I said the secretary writes the name of the transferee on the reverse of the share certificate, on the back part of the share certificate. If the columns are filled, then she prepares a new share certificate. But here, in the case of transmission, she will cancel the old share certificate. It is over, the person is dead, and she will prepare a new share certificate in the name of the legal representative. I have prepared few objective questions for you. So, you can go through on the whole topic of issue of shares. I have the likely objective question, like a question bank how you have, but I have prepared a question bank of only objective questions. So, these are the objective questions that are put forward for you. I have put 50 objective questions, and after going through the topic, you can answer these objective questions. Okay. Total there are 50 objective questions. So, thank you and hope you have understood all the concepts which are in this chapter.
Prudent Scholars, powered by Lupin Pharmaceuticals.